how will it reflect state of MP? No. But when it comes in, notification was challenged in the state of MP, you took a lead like a matter in Devi Sharma and substituted you put the Honorable Supreme Court. There, this Honorable Supreme Court that we wait for the Supreme Court judgment. Supreme Court says that you are ineligible. We have notification is already gone. Same situation this is a matter which cannot be decided without a reply from the state government. It's a case where the reply from the state government has to be given. The state is yet to file reply. It's not that simple as my friend is saying that Supreme Court has passed the order in the case of Devi Sharma. There are 70 cases. The Supreme Court in the judgment of Devi Sharma itself has said that the state should not have ignored the NCT notification as long as it was an therefore, the question of that is copy from the High Court of BR. What submission is this one that they have provided a copy of the comparison of High Court of BR. Yesterday, yesterday it was mentioned before the court. The case court has said like this. They said, no, you go in a review before Devi Sharma. If you feel right there. As far as this matter is concerned, so my suggestion is Devi Sharma is not reviewed. It's a law land. So, Malad said to Malad, it will be agreed to no problem from the state of Bihar. It provided the copy. Purposes it provided this compilation. And the Bihar state Malad makes, please see that the court had again left it to the state of Bihar. As far as that order is concerned.
Yes, why was this Guru Singh filed?
Guru Singh is filed, Malad, that they are now, because they say that after the declaration of law by the state government.
This must be filed by the diploma.
Yes. He said that all these appointments should be.
Why a fresh petition?
It was not even because the reason being, Supreme Court has only declared the laws. Supreme Court has not said as to what will happen to the cases of the appointment which have already been made. That is the issue before that. This issue has to be examined. Because the Supreme Court in paragraph 34 of Devi Sharma itself has said that the state of Rajasthan could not have ignored the NCT notification. But what had happened, the state of Rajasthan did not invite. The state of Rajasthan did not invite the application, did not accept the application of the candidates who were having B.ed. Supreme Court said that was illegal. Once the NCT notification was in existence, as long as it was not declared illegal, the state of Rajasthan was bound to follow that NCT notification. And that is the issue exactly here also. The NCT notification was declared illegal by the High Court of Rajasthan on 25/11.
How does this, the pendency of this case before Supreme Court, how does this hold us back from proceeding?
In the state of UP, well, this is the matter for the state of UP.
And here the petition is by candidates.
But here, the petition is filed by the candidates who are D.ed, who are having D.ed.
Yeah.
Yes. Similarly, that is the candidate. Guttu is the candidate who is having D.ed. Guttu says that before the law was declared by the Supreme Court, the state of UP has made about 60,000 appointments of the teachers, in which the candidates having B.ed degree have also been appointed.
More or less, it's asking for sympathy.
No, it's not.
To save our services. Save the services of B.ed.
No, it's not.
Appointing.
It's not
basically that.
No, it's not simple. It's a law. Law, because any law, it will be.
So probably you are showing us some order are subsequent to the wish.
Yes,
so that indicates that they wanted these people out. The B.ed.
Supreme Court has stated yesterday. Supreme Court has said yesterday in that hearing matter.
Now the best course would be that they have to be out. They have to come out of service, and then thing has to be worked out. If some he's entitled to be adjusted, but not otherwise.
Will have to see the provisions of the RTA. Others will also have to see the earlier.
No, that the Supreme Court has seen already.
No,
Why should we go into all that?
Supreme Court has, what Supreme Court has said, Supreme Court has said that NCT should not have issued this notification declaring the B.ed candidates as eligible to apply for a. This is what the Supreme Court says, and therefore the NCT regulation has been declared to be NCT notification has been declared to be illegal. The question before the Supreme Court is whether this issue of appointments already made was not an issue before the Supreme Court. Supreme Court has left it to the states. Even in the order of Bihar also, they have said we leave it to the state of Bihar. Now the issue was what followers have to examine.
Leave what to the state of the
One of the issue regarding the appointment which have already been made. Because the question, followers will please see paragraph order. Take my
the fate of those appointments.
Followers will please have a look on paragraph 34 observations. Paragraph 34 Supreme Court says that the NCT notification held the candidates having their degree as eligible. In the state of Rajasthan, despite that notification being in existence on the date of advertisement, the candidates having their degree were not held eligible. They were held ineligible, despite the NCT notification in place. Supreme Court said in paragraph 34 that the Rajasthan High Court has rightly held that until the notification issued by the NCT was declared illegal, it was not within the domain of the state of Rajasthan not to apply, not to permit the candidate of B.ed or in participating in the process of selection. Because on that day, the notification was very much in existence. Supreme Court said that once the notification was in place, one of the candidates having B.ed degree also has been permitted to participate in the exam.
The other list. Then, of course, the adjustments will take place between benches. If you want, then we'll hear it. Pass it over.
Which is going to have very wide ramification consequences of my law. Now the down of the state government is very important. I think that is the reason why matter was achieved. It was hard.
Senior counsel, sir, I am also the election were also that it was heard. They were replying, then court master replied that it was an ad hoc bench. Then the matter was split over. But
my vacancies are vacant. Why? Because we have not found, the government has not found eligible candidates, meaning thereby that we have not stressed on the rights got of the d.ed candidates. Still, thousands of vacancies are vacant. So this is an academic exercise in which the my learned friends, petitioners, counsel, clients are indulging.
They are already appointed also.
Most of them are already appointed. Even if not appointed, not this honorable court will be seized of the matter. If some right is transferred.
See,
It is not a PI.
petitioners here are diploma holders.
Yes, they are already
They are,
appointed.
all the petitioners, Lord, they are diploma d.ed holders.
They are already appointed.
So it's not like
They are appointed. They are already
except for the petition, on other petitions, none of the petitioners have been appointed. This is there. If they can show up, this is why
There should be no dispute on this kind of a fact.
it should be very, very clear.
all of them have been appointed.
In one of the petitions,
Yes.
Anyone, or anyone has been brought down because B.ed candidates were not competent on this land. My contention in my return is that out of 25,000, only 22,000 appointments have been made. 2,000 appointments are vacant because these D.ed candidates could not qualify. So their right is not violated. Our participation, my lord, in the selection process has not in any way prejudiced or brought the competition. This is wrong. The competition is still there because they have not been qualified. And
Mr. Rupra, we have this is decided.
only one more thing, Lord, just we are not shying away from argument, but we don't want that contradictory orders should be passed into litigation. My learned friend has given us the.
No, very like, please argue the matter so that we can finish it.
But what the submission is, or we are ready to order. There's no difficulty for now. This submission is, will it not be appropriate to have a reply from the state? It's the state government which has to give out as to how many posts are advertised, how many appointments
They have not filed any reply.
they have not filed. How many posts are still vacant? Whether they are prejudiced because of our continuance in services.
What is the state doing since the last 1 year?
They will not follow because it was their rule. They have given appointment. They want them to continue because that would create a problem for them if someone intentionally then they are sitting over it. They will not find it that.
How can you say that they will not file reply? The court says.
Mr. Bajpayee, in 1 year, state has not come out with any response. Why so? So this is under which department? School education, public instruction. Then what?
They have to say they let the state government also file response.
You will have to, in fact, disclose a lot many things that whether there is any B.ed appointee who also holds a diploma, whether there is B.ed appointees who do not hold a diploma, a chart has to be made. Then can their appointment be axed because of their judgment or not? Whether they can be adjusted or not.
They were in view of the RTE, whether the B.ed
So
candidate.
that has been decided. That question has been decided by the Supreme Court. That the notification is bad in law.
But there is a provision in the RTA that candidates who are having B.ed, they can be made qualified by undergoing that process. That is not a step down. It's not a step down.
Actually, see the courses are totally different. The diploma course and the graduation course in education, and they are different. Different subjects are being taught, different type of education. Teaching is like. This is only for primary education.
Our section,
Primary school.
primary teachers. Our section 22 of the RTA. And the RTA came into existence. At that time also, the B.ed candidates were not eligible.
So we are ready to hear. Please argue the matter.
If they are not, these are not going to
But states reply is a little. No, Mr. Counsel, don't you think states reply is
This is
necessary?
what we require. Know the reason one.
Why not?
Now, let me answer this.
Yes, let him.
Know the reason one. The Ncert notification being binding on the state of Madhya Pradesh, they came up with their book only to bring it in consonance with the NCT notice. Now the NCT notification was quashed by the Rajasthan High Court with 30 penalty, I think. So the Honorable Supreme Court, by upholding the judgment of the Rajasthan High Court, also declared it void.
What did the Rajasthan High Court say about
Said the
the?
NCT notification is
No, that is understood. What did they say about the appointees?
Instead of Rajasthan, my lord, the Honorable High Court granted dispute the appointments. It initially said itself that they will not be given appointment because the High Court was aware of the fact that under the primary education, only D.ed persons are having that ability to teach that any can to go and take over studies of a child.
So there, this problem was not there.
It's not there. They that the Rajasthan High Court, Rajasthan Council, Rajasthan High Court, are in one better away. That
Where is that judgment of the?
is just based in the compilation.
It is wrong that Rajasthan High Court had done this thing. In the state of Rajasthan, the candidates having B.ed were not permitted to participate. See, they were not permitted to participate. Yes, you know.
Because I also want to let me just that means, Mr. Gill, that no person with B.ed degree was appointed there in Rajasthan. So they did not have, High Court did not have to deal with this kind of a situation.
Absolutely. What is happened is there were two petitions filed. One was with the B.ed candidates.
What about the other states?
In other states, that went from Bihar, when the appointments were made, there in
Of B.ed.
B.ed candidates, then the Honorable Supreme Court says that all steps taken subsequent to this notification stands invalidated. That matters what has happened is, in High Court of Bihar, the matter was filed that look, there is a judgment of the Supreme Court. There was also an interim order in the Chhattisgarh matter, which judgment would be binding. The High Court of Bihar said that the Supreme Court judgment is binding. These candidates cannot continue in service. It was specifically clarified. Against that, the state of Bihar as well as Bihar candidates were implicitly. And there was the one SLP was listed before Justice Bopanna's bench. There they said that it should go before the bench of Justice Anuruddha Bose, who delivered at Devesh Sharma's judgment. The matter went before the bench of Justice Anuruddha Bose. Thereafter, arguing it for half an hour, ultimately the petitions were withdrawn. I have placed both the orders on record. The High Court of Bihar has taken up this view. Directly Kevin Sharma as well as the Balakrishna judgment. They are binding in Balakrishna judgment. They are binding in nature. Subsequent thereto all steps taken, steps validated. They have moved before the Supreme Court because the SLP who the state of Bihar as well as the B.ed candidates. Now, whereas one from state of UP come up, there may be from state of Manipur, one can come from state of MP, one can come from state of Chhattisgarh. They are not court. Final view when the notification has been declared invalidated. The appointments were made subject to outcome of the Devesh Sharma's SLP. One of the applicants is Devesh Sharma himself before this honorable court. In whose SLP the judgment was upheld and notification was filed. Now, madam, they want to continue, madam, let it not be the PSCC candidates, let it not be the B.ed candidates. The notification was first keeping in mind the right of those children who are now being allowed to be taught by these ineligible candidates without having a training. Madam, Article 21A is working day by day. Today, also a person who is ineligible to teach is taking up a class. Who is representing that child before the honorable court? We may not go into service, they may not continue in service, but the fact remains that the notification was quashed because it was taking away the right under Article 21A, that is right to quality education. A right to be taught by a person who is very well trained. Now, if a single day continuance of them is infringing their rights.
Where is that judgment of the Bihar High Court?
But I provided a confirmation.
They were dealing with a situation where B.ed appointees were there.
Yes. And can we see what was taken up before the division?
What was the finally?
They said that the judgment of the Supreme Court and Devesh Sharma and Bhagwan Krishna, they are binding. We have to go by that. So meaning thereby that the B.ed candidates have to make room for other B.ed candidates.
What did they say about those appointees? Patna High Court is subsequent to Devesh.
Yes. Patna High Court is subsequent to Bhagwan Krishna also. It's a three-way judgment, knowledge, if I can read this.
Where is it?
I provided
the compilation.
No, it's a separate set. It's provided today, sir. Which is with the Dipankar Gaurav's order. First part is Dipankar Gaurav. Yes. Now this is where the B.ed candidates, B.ed candidates to their SLP. The second order is the Bihar High Court order, 22nd of September. Now, can we see what the Bihar High Court has dealt with? The respondent state has filed the above application. Where is it, Maharaj? The second order is said 22nd of September for the division bench.
Yes, sir. Please indicate.
ये देवेश दीपांकर गौरव ये ऑफर है दीपांकर गौरव What's your target, Mark? I can provide myself.
Have you given 2 copies?
Yes.
D.ed. Like I've given another step. Now, Deepankar Gaurav order number 20 B.ed candidates below their SFP. After arguing for a while, learned counsel for the petition submitted that the client would not like to copy the petition according to expense was withdrawn along with applications. Now, this was withdrawn against this order. That is the next page. The respondent status file.
Patna High Court order.
Yes, ma'am.
This is 22/9. Yes.
The response status filed the above application seeking to clearly allege uncertainty prevailing by reason of the three orders of the Honorable Supreme Court annexed the Ncert of Guarantee. Annexure R/1, the judgment of the Honorable Supreme Court invests the judgment of the Rajasthan High Court, setting aside the notification dated 2018 issued by the NCTE to include B.ed as an eligible qualification for primary school teachers was upheld. It was categorically held that B.ed cannot be qualification for the purpose of selection of primary school teachers to teach students 15 class 45. Annexure R2 was passed in a case where the very same notification was challenged, which was held to have been quashed by the judgment at Annexure R1. The consequential advertisement and subsequent steps taken in pursuance thereof stood invalidated. It was specifically noticed that the state of Bihar was not a party in the above interpretation, but the three-judge bench specifically recorded that it is expected that the state of Bihar will take into account the judgment at Annexure R1. Annexure R2 is a special interpretation where the interim order issued by the High Court of Chhattisgarh, which stated the recruitment process came to be challenged. A division bench of the Honorable Supreme Court set aside the interim order and clarified that the recruitment process would be subject to the result of the consideration of the rate petition, which can only be in consonance with Annexure R1. We do not think that there is a lack of clarity insofar as the binding nature of the judgments of the Honorable Supreme Court at R1, R2, and that there is no apparent conflict in the order at Annexure R3. We find the petition to be misconceived, the interlocutory application stands rejected. So, under Annexure R2 is that order which says that the advertisement on all steps taken thereto is put invalidated. Now, there, my lords, against this, the state of Bihar went into SLP, that is at the next page. It was listed before Justice A.S. Lopanna's bench, which passed the interlocutory order in Chhattisgarh High Court. There, my lords, it was withdrawn. Then it senior counsel for petitioner seeks leave to withdraw the petition, permission was granted, the special leave petition was withdrawn. Then, my lords, the B.ed candidate went before the bench of Justice Anuruddha Bose to deliver the judgment of Devesh Sharma. There also, after arguing for a while on this 31st of October, they withdrew the SLP. In all, my lords, it is very much clear that any appointment of the B.ed candidates based upon the notification of 28 June 2018 and anywhere in the state of in this country, in any state, that is invalidated. They cannot continue for a day more. What do you say, Manav? They were following this mandate.
Okay, so we'll proceed to the other thing.
Just kindly have a look on this. Only one thing, Lord.
Yes. Please cite all your judgments which you are during your arguments. We heard his arguments, we will hear your argument. Please pass it over. Pass it on.
Because he has not, in his long argument which he did just now, he has not disputed that all his petitioners, my lord, have failed to qualify in the test. He so has taken, so lord, that is my categorical submission that the 2000 was not still vacant. And
We can always bring that
and what argument is arguing on behalf of the children. This is not PIL. It is a petition vindicating the rights of those people who probably claim to be displaced because of the B.ed candidates. No, you cannot argue for the children. This is not PIL. First, you tell where is your locus. If we are in our appointment.
All right, Mr. Rupai, a diploma holder has been subjected to selection and found to be unfit and not appointed. Then that's the end of the matter for that candidate. That's the end of the matter. So we'll observe that.
No, that has to be ascertained. That has to be.
We'll leave it to the recruiting agency. Why should we undergo all that? Which?
Why? Because when you have failed to qualify the written test, how you can challenge? See,
Another time they say we have failed. finally said, are you appointed or are you paid?
No, but they have one, they have
appointed. No,
Have you pointed out?
because I'm not appointed, it's not for the
Not the council. It's the council.
my instructions are to now
Please, please.
they have failed to qualify.
Yes. What is your name? What is your name? Why are you arguing with the other council? Whatever you want to say, you have to address to the court, not to the other side. If you want to argue with the other council, go and sit down in the bar room and do whatever you like. But not here.
First, demonstrate that why those 2,000 why the return,
No, let us visualize. Let us visualize what kind of categories of candidates will be there or appointees will be there. One, you say that diploma holders subjected to selection but found unfit. This is one. All right. Diploma holders subjected to selection, found fit and appointed. This is the second category. Third category is D.ed candidates who don't have a diploma, found fit, appointed under the notification of NC. The fourth is the B.ed candidates who do also have a diploma and also appointed or not appointed, we don't know. So there can be various categories which can be visualized. Once the Supreme Court has settled the main legal point,
there are what the starting point should be. There are whether my learned friends
please point out that which diploma holder was subjected to selection but found unfit, and yet he is the petitioner.
It will not be out of place to mention here that 25,000 posts were notified by the government, out of which 22,000 have been. 3,000 are vacant. Means even if we are out, our learned friends' clients will not succeed in this getting. Why they want to indulge in this academic exercise? Because
you make a statement that I am not qualified marks.
the state will be made by the state government. This is not an issue, not which will be decided in piecemeal method. Me and Mr. We are not shying away from education. But we do not want not that today one order is passed, then again the state government comes with some facts. That will create complication.
No, it isn't. The ball is not in their court. The ball is now in the court here. We'll categorize, we can visualize all those categories right here on the basis of facts. And then we'll say you do this with this category, you this with this category, you do this, and thereafter go ahead and fill up the vacancies.
There are two reasons.
This is where they are finding jobs. For 1 year you do not file. Last time it was argued, we didn't raise this submission. It was only for the ad hoc bench. It was not finally. Now, it was kept with this very much clear intention of 30th it would be decided because we were not available on the next 2 days. And I moved an application that I'm not available. Now, once today they make a submission not on legal points, they make a submission that let there be my submission is very limited. But you can still continue. There may be 10,000 available. If you are intended, but do you have a right to continue in circumstances? It's not a public interest. No, I'm not about public interest. I'm talking about a legal aspect number one. You have the legal aspect number two is that despite I have secured the minimum qualifying marks, I have not been given appointment because my
Who is for the recruiting agency? You are for the recruiting agency. That is what? Which is the recruiting agency? You file a reply. Alright, and the interveners are all which category of appointees? Your appointees? B.ed appointees? All interveners?
Yes. We are B.ed.
All.
Because they went to the Supreme Court, Nirdesh Sharma moved that.
We'll ask for your what options are available to you. And then see on the basis of law whether to accept your option or not to accept your option. Give you a hearing. The question is whether it should be here today or not. It's already kind of a barter. I cannot technically say it's barter because it's a different bench is different.
My submission is that it be appropriate that the state government is given a short time to file. So they spent out not as to how many vacancies are advertised, how many persons have been appointed.
Why should we go into all that?
No, that will be required one. That will be required.
That domain.
That will be required.
You can say we can visualize 3 or 4 categories.
That is absolutely.
And then we have to say who is going to be out and who is going to be in those 4 categories, and then leave it to the state to fill up.
The petitioners who are there. There are 2 written. In this petition, there are 2 written. Both those petitioners have been appointed. So as far as one petition is concerned, they are no locus to say anything in the matter because they have already been appointed. The another matter is that my friend says we are not very sure as to how many persons are left.
They are diploma holders.
Yes, they are not. None of them is appointed. Both the petitions, both the petitions, they are the diploma.
They have been appointed.
In one case, they have been appointed, both the petitions. These are the appointment order, and let them say that no, they are not appointed.
You are talking about which case?
Well, this is a responsibility. This is number 1376. In this case, there are 2 petitioners, K.C. Nandan Sahu, and both of them have been appointed. These are their appointments.
The first case.
This is the first.
There are 2 petitioners.
2 petitioners. These are their
K.C. Nandan Sahu
and the other one is Rohit Chaudhary.
Who is representing them?
They are not.
They have been appointed. They were appointed. Then what is your grievance?
The second petition, none of them have been appointed.
No, we are talking about the first one.
The first petition was filed prior to the declaration of results and the advertisement.
Then it is infructuous.
Even if it is held infructuous, it will not be held infructuous for the notification in the release software. Because it is only in respect to one of the part that I should be appointed. But the notification in the rules is still under charge. Actually, it goes with the second of the petition when none of them have been appointed despite securing the minimum qualifying marks. So the second petition also, I am still representing second petition.
Now we come to the second petition.
Now, how is the second petitioner? His cause is still alive.
What's the reason that the vacancies have been occupied by B.ed candidates and we have not been given appointment despite securing the minimum qualifying marks?
You say both have been appointed.
There are 4 petitions. In one petition.
We're talking about the first case.
First case, both are appointed.
Both are appointed.
Yes.
So then would you like to pursue that petition? Why? Why would you like to? What interim order?
Appointments are subject to outcome of the rate. So this petition could survive because all recruitments are subject to outcome. And even if these 2 persons are appointed, the recruitment exercise based upon B.ed eligibility, that cannot be declared infructuous. The second was dealt with this, there none of them have been appointed.
Did you mention in that WP that you were appointed?
That
They are not disclosed in the
the time when the petition was filed.
When were you appointed?
Well, these are 4/4/33.
Yes.
Both these orders are 4/4/33.
I can see when
They never disclosed it. We have been saying
it was filed.
no, thereafter. We have been saying it on every day. And you say, no, we have not been appointed.
First day itself, I said that 2 persons have been appointed.
They should have said
They
that.
are not appointed.
They should have said that.
When did you file this petition? 22/6. 22/6 it was.
Was filed.
All right. File. When was the result declared?
8/8/2022. That was for eligibility purpose, and then appointments were issued by us on 4th of April 2023. Prior to a losses may be recruitment exercise subject to the outcome of the verification of the deviation pass suspend. Thereafter, they moved an IA before the Honorable Supreme Court. That IA was decided, no relief was granted. Then they moved IA before this Honorable Court. Never revealed this fact that we were there before the Honorable Court. I pointed out this fact. They did show them. Then it's taken that petition is already there, and the persons are not being appointed. They are secured minimum qualifying marks, are vacancies being occupied by these B.ed candidates.
Minimum qualifying marks does not give you entitlement to straight away appointment.
Yes, ma'am.
It is based on merit bank.
They said we are ineligible. They said that we are ineligible. Look at that. Okay. And I can only be eligible if I pay to secure minimum qualifying marks.
Yes, so there's another question which arises is when this entire exercise will be considered again, all 3, 4, 5 categories, and then the entire exercise is considered, there may be candidates who are diploma holder who may have been secured more marks than them. These petitioners in Kesari. So then if that is so, then they'll have to be out.
Yes, B.ed candidates.
No.
Even we can be out. Rashtra saying that even we can be out.
B.ed candidates have occupied the posts which were exclusively meant for diploma. Now, once the B.ed candidates are out, in case they are out, then the entire exercise of the select list will have to be made again based on the exam.
Yes.
Was it an exam or what?
It was an eligibility examination. Was an exam? It was even though not reservation applied, yes, we are listening everything.
Lot many things will have to be reworked.
Pilot man for that, the state will have to give out a reply. The state will have to come out with the figure. 35,000 vacancies were there. Why only 32 were appointed? 3,000 candidates were not found eligible. These candidates were not able to be qualified in the examination. We do not know that. Now we are carrying out this whole exercise at the instance of these candidates, out of which 2 have already been appointed, and remaining we do not know whether they will qualify in the eligibility examination. We do not know that. Why would I come before the court? I do the simple, if I am ineligible, why would I come before the court? That is argue this one. And then one of them said that clearly qualifying in the examination to not secure the appointment, that their merit position has to be seen. So the state has to give a reply to that, what would be the position in respect of each candidate. Scorecard is there. If you go out, I will come in the cutoff. So you just answer it how you are there to prepare your service. Unless you look at it. So that same issue was raised.
So I think lot many things will have to be reworked.
एक सेकंड में सर ये petition देखेंगे आप
नहीं ठीक है
सुप्रीम कोर्ट में लगा
आप बताइए पर
इसको सर स्टेट पर
stop करेंगे आप No, not movies. You're waiting for 1 year without filing any reply. Sit down with your OIC and make your reply this week. We'll place it next week. Otherwise, everything will be washed out the memory. Week commencing 20th will.
What's my idea?
Which IA? We'll hear you. You have a right to only audience, nothing else. You have no right to any relief. No, please don't complicate this. We'll hear you, that's all. Well, it's been clear that state, unfortunately, has not yet responded to the petition despite the same being pending more than 1 year. Next. The state council is present. The court is directed to file a reply positively within 10 days. So there is a controversy which has foundationally been settled by the apex court by B.ed appointment.
Petitioners are not here. Petitioners are here.
Diploma. All appointed by diploma. Next, the list in the week commencing. 20th November. Huh? You can appear virtually. Virtually you can appear. Why do you travel all the way?
Why? How do you understand now that this technology is very, very
Use it.
also.
Use it. What is the technology for if you don't use it?
Plus, one person appearing on the physical side and appearing on others through PC.
We allow hybrid hearing. Why not? No, we don't know because we give you a date. On that date, maybe we have already fixed about 1 or 2 already cases which will take time. So let the computer decide. Computer, searches for vacant slots and then decides in those 5 days, 5 working days. So it can be between 20th and 24th. No, not 20.
23rd.
Let the computer decide. You come to know from your colleague here. So Thakur will tell you what date.
Everything would be matter. Everything would be matter. Again, those
That's why the short date is there. There cannot be more. It cannot be a shorter date. We will give short.
Kind enough, same kind of that extended provide me anything. How you not choose any date?
We will come to know about the date. In
The nature that
advance, you will come to know the date. At least 1 week in advance.
that would be a tentative date, that will not ensure the skill of the case. That is what my son.
No, it won't be a tentative date. This would be issued prior to the Diwali vacation of that week, I think. It will be issued on 9th of November. It will be issued. That 20th week commencing 20th list.
Then my insight of this would be whatever date we show whether the matter would be listed on that day, that is what my anxiety is. But it is tentative in the nature that it may then be postponed by the registry itself. That would be difficult to
That normally doesn't happen.
That is why
When we give a fixed date or a fixed week, it is always listed in that. Always. Next, it is made clear that the State Council should ensure filing on the reply, failing which coercive steps would be taken against the state functionary.
Otherwise, again, they would seek some adjournment for again.
It is the parties are at consensus that the matter would be heard finally in the next stage.
Yes, right.
2188 1800. Oh, and तो लगे हैं picture. State functionary. State functionary. You want that to be also added? Higher continuous.
Number 8 is Mukesh Kumar Pandey.
Yes. In favor of why? How much delay is it? 84. Focus on admission, and IER for delay. Here within 7 working days. Honorable 6 weeks. Record.
Number 9.
Yes.
Not granting lower deduction certificate by the income tax TDS office. And it creates jobs to the government. And there is specific rule and specific section is there. And avoiding this mandatory rule, the section was done. For
Have you moved any representation?
there is no rule for representation in this case because they have already rejected. They have applied to
Why is that rejection?
rejection is not safe. It's a P5
Yes.
and also P7 is there. Because the rejection they have said the application under section 97 of the ITI has been received in this office on Treasury portal along with its inclusion for assessment year 23-24 number so in the case of Royal Cargo Limited. The applicant is requested to issue lower deduction certificate at nil rate under section 194C in favor of many deducted on receipt of rupees 149 crores. Since the applicant has not submitted any explanation regarding the query raised, the application of lower deduction certificate is being rejected. It is completely wrong order, Lordship. Because Lordship, we have filed the reply and also through email, and reply has to be filed through press report. They cannot say this. And again, therefore, Lordship, we again move the fresh application by dimension P6, and they have now Lordship kindly see P7, what they have mentioned in the order. P7.
What is this LDC?
No deduction.
What is that?
Lordship, suppose Lordship, the deductor has to deduct 10%, and there is provision in section 97 that we can apply for lower deduction certificate, and if we fulfill the condition under Rule 28A, only he has to see Rule 28A. They can provide, and in immediate Lordship 3-4 years they are providing me.
This was issued when P5.
P5 was issued in somewhere in Lordship June, and therefore Lordship we again move the application in July.
There is a date in this.
No, Lordship, no date is there. Lordship, they were sending it through Lordship portal. In the P5 also there is no date, but they have mentioned our application date.
Where is the application date?
In the Lordship, in the column Lordship, date. Request number is there, PAN number is there, financial year is there. And Lordship, again P5 they have rejected. And the reason which was given is beyond the purview of the TDS officer in P7. He is saying that we are showing low net profit.
Mr. Sharma, you seek instruction. Tell us.
But it is very urgent matter because Lordship, day to day, Lordship, I agree with you. Nothing very important.
We are giving you time to seek instruction. If Mr. Sharma, who is available in the court, is directed to seek instruction in the matter. Next para. The counsel of the petitioner directed to supply. Have you supplied?
Yes, yes.
Advance copy of the petition and already supplied. Yes. Next, this is the case the last week of November.
My concern is that also in these to be commencing because also day to day also TDS has been deducted also and already up to 68 lakh.
Just a matter of 15 days. At least we should give them 15 days. We missed in the last week of November. Next, the name of Sri Sharma will reflect in the process for the living the next one.
Number 10, see, the party.
Yeah.
Next P1 on 25 to 21. He issued directions to the testing that to comply with the order and the session over to the bank. Nothing else.
Yes, you seek instructions.
Identical orders have been passed as
Sweet. Which case with this petition does not assail any specific order, but it is agreed by the inaction on the part of the respondent number. Point number 2.
This character 3 and 10.
There's still number 3. Number 3, to execute the order of the district magistrate passed on so and so under section 14 of the Surfacia 25/320. Next. Considering the short prayer made, petition with the consent of the other side is disposed of, with the direction that in case the order dated 25/3/21, the district magistrate, city, Jabalpur, E1 has not yet been executed, then the same shall be executed within 15 days. No, 545. But not at 30 days. Within 30 days, the date of receipt of copy of this order, by handing over the possession of the secured asset to the petitioner, the bank or a financial institution. Financial institution.
Your number 11 with connected matter. The chapter 1, AC Thakur.
Yes.
I have also sent the copies of all these cases to the department. So, ETS section, you want to give there.
How much more time you want?
4 weeks more time. In the morning, we are
Is any objection? Sharma has been appointed as amicus curiae to assist this court. Is or is granted further 4 weeks time to seek instructions. After 4 weeks. After 4 weeks.
Your number 12. The Christian Yalo.
There is a final hearing date. Admission. The court आ गया इसमें. What is the issue in court? Yes. That was dismissed. Allowed. Last time क्या हुआ? The court is available, but the other counsel for the petitioner is not ready with arguments. Just after 4 weeks. After 4 weeks. If it is listed on a final hearing day, you should be ready. If you're not ready, you will not create a witness. You go after 4 weeks.
Your number 13, Chief Abhijit Thomas.
Yes.
We want to have the order of prospecting 770.
Mr. Bhaumek, you were not well earlier, last time.
Yes, sir.
Now you are okay.
Now,
Recovered. You can argue. All right. Yes.
All confusion arose due to the order passed in first appeal number 771 of 2016, which was finally decided on, which my lord has the order, has the record of since 771 of 2016. The final judgment dated 12/4/2009. My lord, may kindly come to the last paragraph.
Mr. Bhaumik, there are two review petitions.
So the conclusion is that only these are two review, your lordship.
Then
The simple is that, your lordship, two contempt was also pending along with this first appeal. Argument was heard in first appeal. I was medically adjusted on that day because my leg was fractured on that particular day and I was medically unfit for 1 month. And these two contempt has been decided along with this. This is it. And these are not review, your lordship. These are the restoration. They were filed in MC. Honorable Court was of the opinion by the order dated 13/11/2019 that convert them to review application by filing an appropriate application. Madam, we kindly see the order dated 13/11/2019 passed in MCC number 1182 and 1183 of 2000.
in the connected thing.
This is all you. This is the entire. My respectful submission is worship. The appeal, that's a separate case. And therefore, your lordship, I have also tried the written arguments in both these review. पूरा confusion में review लिखने के कारण.
We should see RP 1297. Is it not?
1296, 1296, 1297, दोनों एक ही.
MCC 1182 में है ना?
1182 and 118. इसका order dated 13/11/2000. It was the Honorable Court was of the opinion that it is only to convert them into review.
1182 का नहीं है देखो.
Below the find the order in 1183 also. Order dated 13/11/2019.
MCC record is not here. RP record है.
So ये MCC से ही review में convert. By the order of Honorable Judge.
Convert to me.
13/11/2019 का order. The order says so. Shall I read it?
Yes, we've seen that.
The yearly submission in view of the order dated 28/3/2019, the present application for restoration may be permitted to be converted as review application by filing appropriate application for conversion. Therefore, I want restoration goes to contempt. If my lord be kind enough to convert them or permit them to review, then I will be able to argue.
Let us see what order was passed in the contempt.
Right.
In view of final order passed today in FA 771,
Right.
petition has become in question.
Right. Now, my lord may kindly keep the last paragraph of 771 of 2000. Paragraph 17 and page number 4.
दोस्तों चैनल को सब्सक्राइब जरूर कर लीजिएगा अगर आप इस चैनल पे नए आए हैं तो.
9 pages.
Runs into 14 pages.
और वीडियो को लाइक कर दीजिए.
1 of 2016, judgment dated 12/4/2019.
अगर आप इस चैनल पे नए हैं तो एक बार चैनल को भी जरूर सब्सक्राइब कर लीजिएगा.
जिससे लिंक किए दोनों कार्यक्रम